Welcome to the Employment Law Channel. Social media is where an employee's work life and personal life often collide. In this discussion, we're going to talk about how to handle employees' use of social media and privacy in the workplace. My guest is Wendi Lazar. She is a partner at Outten & Golden. She heads the Executives and Professionals Practice Group. Wendi, welcome back.
Oh, thank you, Scott. Good to be here.
With regards to privacy expectations, where does an employee or a prospective employee stand with regard to his or her use of social media?
Well, it's very interesting and a very timely question, Scott. A couple of weeks ago, actually, the NLRB came down with a decision. That's the National Labor Relations Board, which of course oversees mostly union issues, but they also apply to employees very broadly in the workplace and the private workplace as well. And the NLRB came down with a decision that essentially really tossed out Costco's social media policy, because it basically, at pain of termination, would really prevent its employees to associate and discuss workplace conditions. Just to go a little deeper on this, Costco's policy said that you could not go on any social media and damage either the reputation of the company or damage the reputation of employees or management at the company. And this decision, the NLRB really equated to preventing workers from discussing conditions at the workplace, which has been a very long-standing principle in American employment law.
So, and I guess with regards to that sort of talks about, I mean, social media is not, again, an extension of free speech, really, in one sense, isn't it?
It is. It's associational rights. I would say that, you know, in the olden days, the cases were around the water cooler. Could you say to your workmate, so and so, my job is too hard, I'm being underpaid, I'm being overworked. Could you discuss conditions at the workplace, at the water cooler? And it kind of filtered down to these water cooler laws, which the NLRB has always, mandated as being associational rights that workers have in the United States. And these rights are certainly, involve freedom of expression and other associational freedoms that we hold so true in our Constitution. But there is another side to this, of course, Scott, as we've discussed. There's also decisions that come down and have come down over the last few months that really draw a very fine but definite line in the sand that any social media comments are not okay. And all social media comments made by employees are not okay. And in fact, yesterday there was a decision by the NLRB holding an administrative law judge to a decision where he found a BMW dealership, an employee at the dealership had gone on Facebook and showed terrible pictures of an accident, in fact, that involved the dealership in a really negative way. In fact, a child, I think, had gotten behind the wheel and gotten into an accident. And the NLRB said, this is not okay, this is not protected speech, this is not we can't protect this kind of behavior or mandate this to be protected speech. So that's the other side of it. That's the flip side of this issue, that you can talk about working conditions at the job on Facebook, on MySpace, on, of course, different social media systems, but you cannot really damage or disparage or say things about the company or the workplace that will clearly damage the reputation of the employer.
Let's talk about privacy and social media from a different perspective here, from the employee's perspective or prospective employee. It's become pretty common for employers now, in some cases, to access social media to make a hiring decision. Now, talk about how that can happen and what recourse an employee has if that actually happens to them.
Well, this has been an interesting issue for a couple of years now, because if you look at the data on recruiters and human resource professionals, the statistics are staggering. There are over 50%. There are over 50% of HR professionals and recruiters are actually looking at social media data to assess someone's hireability. And so being aware of that is really important. And the fact that it could get employers in deep trouble is also important to realize, because if you use information not to hire an employee because they're someone in a protected group, they are someone who may be over 40 and so they're protected by our age discrimination laws. It could be someone of a certain ethnicity or racial profile. If a decision is made, or even someone who's obese or disabled, I will go even further, any of our protected employment civil rights areas, if you make a decision based on that, there could be terrible liability for the employer. There's also, I guess, not really the flip side, but an ancillary issue here is also at the workplace. If someone is terminated because the employer went into or had access to a social media site where the employee was also associated with a particular ethnic group or espousing to certain religious beliefs or anything like that that could actually be considered their termination could be considered discriminatory based on this evidence that the employer has gathered. This could also lead an employer to increased liability. So I think that that is an issue. Certainly it's an issue also for the employee. We tell our employees that come to our office who are either considering bringing an action about discrimination or even a contract action against their employer, we counsel them not to spend a lot of time online. If they are on Facebook and they are on another social media site, to be very, very cautious to make sure those privacy settings are set and that others, third parties, do not have immediate access to information. We tell them to be very, very conservative about communicating on Facebook. And I will add one more piece, which I tell a lot of younger professionals that are entering the job market. Be careful what you do on Facebook. Be careful what you do on other social media sites to really represent yourself in a way that you would not want a potential employer, recruiter, or HR professional to be looking at you in that way.
Well, Wendi, it's been very, very helpful here. We appreciate you sharing your expertise with us today. Thank you.
Great. Thanks so much, Scott.